All right, let's talk about one of those classic neighborhood showdowns. A homeowner going head-to-head with their homeowners association. It's a story that starts with something as simple as a painting project, but wow, it quickly spirals into a full-blown legal battle over money, power, and the fine print in the rules.
So let's just get right to the heart of it. Here's the big question. Can your HOA make you foot the bill for their big community renovation? I mean, even if it means you have to tear down a part of your own property? For one couple out in Arizona, this wasn't some hypothetical question. It became their reality.
Okay, so let's meet the people involved. On one side, you've got the homeowners, James and Shawna Larson. And on the other side, their HOA, the Tempe Gardens Townhouse Corporation. And the whole thing got started because the HOA decided, you know what, it's time for a fresh coat of paint for the whole community.
And this is where things start to get sticky. The HOA sends out the notice. To get the painting and repairs done right, every single patio cover has to come down. And here's the kicker, the homeowners were on the hook for the cost of removal. So the HOA basically laid down the law and there was zero wiggle room. They said you have to remove your patio cover. If you don't, we'll do it for you. But either way, you're getting the bill. You can imagine for the Larsons, this felt a lot less like a community project and a lot more like an ultimatum.
Feeling like they were backed into a corner, the Larsons decided to fight back. They took legal action and filed a petition against their HOA. But their day in court? Well, it hit a brick wall, fast. The first judge who looked at the case pretty much said, "Whoa, hold your horses, it's too soon for this."
And man, it was quick. Take a look at this timeline. They filed their petition in the middle of June. By the end of August, just over 2 months later, a judge is already recommending the whole thing gets tossed out. It really looked like their fight was completely over before it even got started. So why? Why did it get shut down so fast? Well, it all came down to this fancy legal term, justiciable controversy. Basically, it means a court only deals with real, happening right now problems, not what-ifs. The judge looked at it and said, well, the HOA hasn't actually ripped down the patio cover yet, so there's nothing for me to rule on. And here it is, straight from the judge's mouth. She called the whole thing speculative. There was no real action to judge. Can you imagine how frustrating that must have been? You have a direct order from your HOA, but a court tells you it's too soon to fight it. It's a total catch-22.
But hold on, just when it seemed like the HOA had won without even trying, the story takes this wild turn. A higher authority is about to jump in and completely flip the script, proving that the first ruling was definitely not the final word.
So here it is. This is the official document from that first judge, dated August 25th, recommending the case just be dismissed. For all intents and purposes, this should have been the end of the line for the Larsons. But then, get this, just 6 days later, this lands. It's an order from the Arizona Real Estate Commissioner, Judy Lowe. And look at that, right there in black and white, order rejecting recommendation of dismissal. In this absolutely stunning move, a higher power just overruled the judge.
The commissioner used a different legal phrase. She said the case was ripe for adjudication, which is the total opposite of what the first judge said. She was basically declaring, oh yeah, this is a real dispute and it deserves a proper hearing. And just like that, the Larsons case was back on.
So, it's game on. On November 20th, 2017, the Larsons and the HOA finally got their official day in court. This was it, the chance for both sides to lay out all their cards and make their arguments for the record. Okay, so a huge piece of this fight was about the money. And you got to see the gap between what each side was saying. The Larsons came in with estimates that were well into the thousands of dollars. But the HOA, their first guess was just $225, and their project manager later said $1,000 should do it. I mean, that's not just a small disagreement, that's a massive difference. So the HOA built its case around two things, necessity and safety. Their project manager got up and testified that new OSHA safety rules meant they had to use scaffolding that just wouldn't fit under the patio covers. He also pointed out that every single one of the 5 contractors who bid on the job said the covers had to go. And to top it off, if they let homeowners paint their own walls, the paint company wouldn't warranty the job. Now, the Larsons' argument was pretty straightforward too. First, they said the cost was just flat out unreasonable. Second, they pointed out that they tried to meet in the middle, even offering to hire their own painter for their section to solve the problem. And third, they reminded the court, hey, this patio cover isn't some new thing we just built. It was here when we bought the place way back in 1999. So all the evidence is in. The new judge has heard both sides.
But the final decision wasn't just about who had the better painting contractor. No, it came down to a very specific reading of the HOA's own rules. And, this is the important part, Arizona state law. The first domino to fall was this legal idea, limited common element. It's a really key concept for anyone living in an HOA. It just means something that's technically part of the shared community property, but is for the exclusive use of just one homeowner. And the judge officially labeled the Larsons' patio cover as exactly that. Now, why did that label matter so much? Because of this. This right here. This is the exact wording from an Arizona state law, and it basically became the knockout punch in this case. The law is super clear. Any cost related to a limited common element, like that patio cover, gets charged directly to the homeowner who uses it, not to everybody else.
So you can see exactly how the judge got there. The logic was simple, almost like a math problem. Step 1, the patio cover is a limited common element. Step 2, the law says the cost for that goes to the homeowner it benefits. And so, the conclusion was inescapable. Step 3, the Larsons have to pay for their own patio cover.
And that was it. The final verdict came down. The Larsons' petition was dismissed. The judge ruled that the HOA was completely within its rights to require the removal, and that the financial burden, well, it fell squarely on the Larsons.
So, the case is closed. The Larsons lost. But what can the rest of us learn from their long and probably very expensive fight? This isn't just a story about a patio in Arizona. It's a huge lesson for literally anyone who lives in a community run by an HOA. And this, right here, is the #1 takeaway from this entire thing. Those documents you get when you buy a place in an HOA community, the CC&Rs, they're not just friendly suggestions. They are a rock-solid, legally binding contract. And when you combine those rules with state law, you have an agreement that the courts will enforce.
So I'll leave you with this question to chew on. Your relationship with your HOA is a contract, plain and simple. Those rules can dictate what you can build, what you have to maintain, and what you have to pay for. The Larsons learned the hard way what was in theirs. So the question is, have you actually read the fine print in yours?